Hey guys, and welcome back, and if you're new to our channel then welcome. Today we will be discussing void and irregular decree. Couple of videos back we discussed the difference between judgment, decree and order. If you haven't seen that video, I will link it on the screen so you can see that video before you see this one. And if you've seen that video, then let's just jump into the continuing with the difference between judgment, decree and order. This is a sort of continuation from that, because today we will be discussing the difference between void and irregular decree. Now, in that video we learned that the decree is something that conclusively determines the rights of the parties with regard to any or all the matters in the controversy, and a decree can be passed by a civil court. So far so good. We know the meaning of decree, we know it's passed by a civil court. But what makes a decree into a void decree or an irregular decree? That happens when certain restrictions which are placed on the civil court are transgressed by the civil court. Every civil court has certain restrictions when it comes to jurisdiction, and if those conditions are not met or they are not fulfilled, the decree will turn out to be void or irregular. So what are these restrictions which are there on a civil court? Let's find out. First of all, section 9 of the Civil Procedure Code provides jurisdiction of civil courts, and it says that the court shall have jurisdiction to try all suits of a civil nature, excepting suits of which the cognizance is either expressly or impliedly barred. Now, section 9 is a huge topic. In fact, every jurisdiction is and deserves a video of its own. But for today, we'll just understand the basics of it and just understand what's required for us to get to the point of void and irregular decree. So section 9 says that for the court to have jurisdiction, it has to be a suit of civil nature and it should not be expressly or impliedly barred. So far so good. Must be civil nature suit and should not be barred. If these two things are there, the court will have jurisdiction. In addition to this, the court must also have pecuniary, territorial and subject matter jurisdiction. Now what does this mean? Pecuniary jurisdiction is provided in section 15. It basically means that the case must go to the court of the lowest grade. And if you read the section, you'll understand it's very basic. Every court has a certain amount of pecuniary jurisdiction. If the case is valued up till 20 lakhs, it will go to the lower court. If it is more than 20 lakhs, it will go to the higher court. It depends on state to state. Pecuniary jurisdiction is decided, and the court must have pecuniary jurisdiction to try the case. For territorial jurisdiction, you should read section 15 to 20 plus 21 and 21A. That provides for territorial jurisdiction, that the court has jurisdiction for the cases which falls within its territory, and in what cases can it decide cases which are outside of its territory. That provides for territorial jurisdiction. And then there is subject matter jurisdiction. What that basically means is that certain kinds of suits are limited to certain courts. For example, there are specific courts for testamentary succession, there are special courts for divorce cases, there are special courts for probate proceedings, for rent matters. So, a court which has been given the subject matter jurisdiction for rent cases, and it is the rent tribunal, that cannot deal with divorce cases. So they do not have the subject matter jurisdiction to deal with divorce cases. They can only deal with rent cases. So whatever subject matter is assigned to that court, the court can only deal with that subject matter, no other subject matter. This is very important, and the court must have subject matter jurisdiction to deal with the case. Now, so far we have learned that a civil court should have jurisdiction under section 9. That is, it should be a suit of civil nature, should not be barred. The court should have pecuniary jurisdiction, the court should have territorial jurisdiction, and the court should have subject matter jurisdiction to try a case. All these jurisdictions should be there, and all these essentials must be met before a court tries a case. And if they do it without the jurisdiction, then that leads to a void or irregular decree. How? Let's understand. If the court has no subject matter jurisdiction, or if res judicata applies, and res judicata is given in section 11. If you have even the basic idea of CPC, you know what that means. But that's just too big to cover in this video. So if you want a basic understanding, just read section 11, and that is res judicata. So if the court has no subject matter jurisdiction, or res judicata applies to the case, and in spite of that the court passes a decree, then that decree is void. which basically means, for example, is that a rent tribunal passes a decree on a divorce case. Is that possible? No, they don't have the subject matter jurisdiction. They only can deal with the subject matter of rent. In that case, the decree passed would be void, because the court has no competence, it has no inherent jurisdiction to try the matter. However, if the court does not have pecuniary or territorial jurisdiction, that does not go to the heart of the case, it does not affect the merits. And in such a case, if the court passes a decree, then that decree is merely irregular, or also sometimes called illegal, but it is not void. So if the court has no subject matter jurisdiction or res judicata applies, then the decree passed by this wrong court is going to be void. But if the court merely does not have pecuniary jurisdiction or territorial jurisdiction, then the decree passed will be irregular. So if the limit of that court was just 20 lakhs rupees and it tries a matter which the value of which is 50 lakhs, in that case it did not have the pecuniary jurisdiction, but it tried, it passed a decree, then what happens to the decree? The decree is irregular, but the decree is not void. It's merely irregular. So what does it basically means for a decree to be void or irregular? What is the fate of these decrees? Let's understand that. A void decree, if it is passed by a court, then it's of no use because it's void, and it can be set aside in appeal, it can be set aside in revision. However, an executing court cannot set aside the decree, because the basic principle of executing court or executing a decree is that the executing court has no power to go behind the decree. However, if the decree on the face of it is void, like the example we took where a rent tribunal passed a decree on a divorce matter, in that case where on the face of it is apparent that this is a void decree, in that case the executing court can refuse execution. That's the maximum it can do. It cannot set aside the decree, but it can refuse execution. Also, a fresh suit can be allowed on the same subject matter, which will lead to collateral proceedings, which basically has the effect of setting aside the decree. So appeal is possible, revision is possible, fresh suit is possible, and an executing court can refuse to execute a void decree. So basically a void decree is useless. And what is the case of irregular or illegal decrees? So if a court did not have pecuniary or territorial jurisdiction and they passed an irregular decree, what happens? Now, because irregular and illegal decrees do not affect the merits of the case, and so in this case the decree is not void, so it cannot be set aside in appeal and it cannot be set aside in revision unless the conditions of section 21 are met. Now, section 21 of CPC provides that an objection has to be raised, and if the objection was not raised, then you cannot question the decree later on. So if an objection was raised, then it is possible to set it aside, but if no objection was raised under section 21, then it cannot be set aside by appellate or revisional court. Also, as the executing court has no power to go behind the decree, if they can't do it with a void decree, there's no chance they can do it with an irregular decree. And in this case, they cannot even refuse execution. And lastly, fresh suit is not possible as the merits of the case were not affected by territorial or pecuniary jurisdiction. And also the landmark cases, the authority on what we understood today and what we learned today is as follows. There is a Supreme Court case of Balwant and Vishwamitra and others versus Yadav Sadashiv Mule, which is a 2004 Supreme Court judgment. And also another 2004 Supreme Court judgment is Rafiq Bibi versus Sayyid Waliuddin. A lot of time there are application based questions on this topic where they will give you a long case, a long list of facts where the court takes up a case which it does not have jurisdiction for, and in the end they say what should happen to the decree in this case, what will happen to the decree which is passed. So in that case you have to decide whether the decree is void or irregular, and you have to give the judgment according to that. If I can find a question from a past year paper, this was the topic on which the question was on, I will try and put it on the screen. See you next week, and don't forget to hit the subscribe button so you get notified of new videos.